This session I'm particularly excited about. We're here to explore a piece of law, some legislation laws written in another language. A handful of you in this room have a legal background and are qualified to work to interpret this, but for the rest of us, law seems like English, but it's more parcel tongue than we probably think. And language is hard. Sorry, I guess that's a deep like the ocean moment. Language is hard. Getting law written is a Herculean task. Everyone on earth, even if they agree on something, getting something codified into law is extremely hard. That's a perfect piece of legislation, said no one ever. Trying to get law nailed down, get it codified correctly, is extraordinarily hard. Complex systems, just like in technology, have emergent qualities and unintended consequences. Understanding how the law impacts the rest of the systems and all that exist in that ecosystem is extremely complex. If a more perfect union's working to grow and continue this fragile experiment we call the United States, there are lots of checks and balances. There's a lot of forces in play. I want you to imagine for a moment if there were people that were eminently qualified to try to interpret these laws, to try to make them work in a considerate way and explore and understand those unintended consequences. I'd want you to imagine those people were teams that weren't government cronies, that weren't phoning it in, that weren't slacking off, representing the man or trying to hold us down. Today, you're in for a treat. I wanted to tell you that I was skeptical that there are folks on the Hill doing the government thing that could be this qualified, that could bring a pedigree like a BA and a JD from Yale. Our speaker today is from the Department of Justice. Back in '91, 24 years ago, was on the terrorism and violent crime section. Most of us haven't been in our chosen career path for that long. In 2000, he joined the computer crime and intellectual property section, that's CSIPs, 15 years ago. Served as special counsel on national security since 2008. He also accepted a position as a senior counselor to the Assistant Attorney General for National Security. He worked in 2012 to set and manage cybersecurity policy. Your speaker today is someone that I had the chance to meet a year ago, and over the last year I've gotten to know and appreciate, respect, and look up to. He's someone that has set a tone for me and an appreciation for people working hard to understand what we do and how the law doesn't understand us. His perspective today should be something very special, and I'm very excited. Please join me in welcoming Leonard Bailey.
All right. Well, good morning. Thank you very much for that introduction, Trey. Let me say that I'm very, very thrilled to be here. And I think this is a great opportunity for us. We used to actually come to Black Hat years back, and then travel budgets and things interfered with that. I think that's a missed opportunity because I think this is a very special conference, special in a number of ways, not just because whenever I come here I feel like I need a full body Faraday suit or something, but because the group of people who are here spans so many disciplines. I know people here who are lawyers, people here who are policymakers, people who are technologists. It just seems to bring together a very large community that's working on a common problem. So before I get into the teeth of my talk today, I wanted to say a word about my office, CSIPs, that Trey mentioned, the Computer Crime and Intellectual Property section of the Department of Justice. The reason I want to do that is it might make a little more sense to you why we're here today. So in CSIPs, we're responsible for training and supporting the network of US attorneys across the country who do cybercrime or complex computer crimes. And in that capacity, we are charged with learning about cyber threats, new technologies, and how those would apply to the laws that we use every day. Now, we are knuckle-dragging prosecutors. We do all the things you expect prosecutors to do. We, for example, recently were involved with the Western District of Pennsylvania and the FBI in the taking down of the dark market. We were responsible for the Game Over Zeus disruption on the law enforcement and legal side, the connected ransomware takedown of CryptoLocker, and the subsequent indictment of Evgeny Bogachev. If you look at our website online under CSIPs, you'll see there's a list of various types of criminal prosecutions that we've done. So we are knuckle-dragging prosecutors, but we're knuckle-dragging prosecutors who do tech. And in that regard, we have a great deal of respect for the people in this room who understand and appreciate how hard it is to get tech right and how quickly things can change. So probably in the last year, we have devoted additional resources towards getting on the prevention side of the equation. You know, we still prosecute people, we still try to reduce the threat through that means, but we also are trying to get to the prevention side. And just in December of last year, we announced the creation of something we call the Cybersecurity Unit, which is focused on working with the public and private sector on identifying and addressing legal impediments to adopting better cybersecurity practices. In that capacity, we've done a few things already. We, in April, for example, released a best practices document that lays out best practices for responding to and reporting cyber incidents. That's kind of a nuts and bolts guide of what to do before, during, and after a cyber event. We are looking at the issue of active defense, trying to figure out whether there's something productive that we can say that will help companies that are thinking about what they can and can't do take action to protect themselves. So in that capacity, we very much appreciate people who do work that looks a lot like, well, stopping things before they happen, detecting the vulnerability before it's exploited and preventing it from actually manifesting and becoming a crime. Now, in our outreach, and this is part of what this is to this community, one of the things that we've heard, and we didn't have to hear it from the community, if you read any tech blog, you know, there are concerns about the CFAA and how it may be, let's say, chilling legitimate computer security research. And that is something that does in fact concern us. This talk is not going to be a legal talk. I think it's correctly characterized in the guide as a talk about risk management and compliance. And my goal today is to provide you with information that you can use to better manage your risk when you are doing what you do, and ideally some advice also towards the end that may help you shrink that risk. So with that as a preface, let's get started. We're going to start off by providing you with some information on the frequency with which we're using the CFAA, and also the circumstances under which we are using the CFAA, so you have some notion as to how we're thinking about our charging decisions. Next, I'd like to talk a bit about sentencing. I think there's some questions about how sentencing works in the CFAA and some concerns about some overcharging. And then lastly, I'd like to talk to you about some factors, some things to consider that might allow you to conduct computer security research with a greater degree of confidence. Now, the one thing I do have to say is I'm here as a government representative, and that means I have a certain amount of overhead. And that overhead means, for example, that I cannot speak about any pending criminal matter. And that's not because of fiat, that's because of actually regulations that prohibit that, that are driven by fairness. We are not allowed to talk about pending matters because we are not to taint the playing field in the interest of making sure there's a fair prosecution subsequently. Also, to the extent that there are departmental officials who have made pronouncements who are far more important than me, I am not going to be able to countermand whatever they have said. Now, with those two caveats, let me say that I will be as frank and candid as I can, and I will be planning on leaving some time at the end for any questions that you have, and as was mentioned, I'm happy to stay around through lunch for those of you who either don't have friends or don't have lunch plans. So with that, again, let's get started. We're going to start with a slight Schoolhouse Rock moment. Now, we know that there are actually two kind of sovereign governments in the United States. One is the state government, and the other is the federal government. Now, in the federal government, we have the 94 U.S. attorneys' offices. This is on the law enforcement side, prosecutorial, who are spread across the country. And those U.S. attorneys' offices are run by U.S. attorneys who are quasi-independent. They exert a decent amount of independence. They're presidentially appointed, but they all operate under the same code of conduct and are subject to the same federal laws that all of us attorneys in the federal law enforcement world must abide by. In contrast, there are approximately 56 territorial and state attorney generals, and each of those officials sit over a state or a territory, and they have their own rules, and they're independent from each other. So I raise this because one of the things that has come up, very briefly, is just a few months ago, I think in Florida, Tampa, there was a middle schooler, for example, who was apparently charged with a felony for shoulder surfing his teacher's password and then logging on to the school account and playing some mischief or something. And that wasn't the only instance. There was, in the same time frame, another incident in Montana, and then last year in June, there was something out in New Jersey. And I've gotten emails from people saying, really? Really? For that? And I had to explain that it wasn't us. Not speaking to the merits of the case, that those cases were brought by state or local governments, not the federal government. So one thing I would just propose is when you hear about a case and you think, well, what's going on there, that you at least remain conscious of the fact that there are different parties that bring these sorts of criminal enforcement actions. Now, speaking of the CFAA, as I said, this isn't a legal talk, but I should flag that the CFAA is not actually one single offense. In fact, it is a suite of 7 or 9, depending upon how you count them. But the ones that you will most likely encounter in the work that you do are 1030A2 and 1030A5. Now, the 1030 statutes are really predicated on this idea that you have property. And 1030A2 is a property theft crime. So it's essentially saying, you have accessed my computer without my authorization, you've come onto my property, and you've taken my information, you've taken my stuff. A5 is you've wandered onto my property and you've broken my stuff. That, in essence, are the sorts of offenses that I think you will most likely really face as a computer security researcher. Now, in talking about criminal matters, I have broken this talk up essentially into 3 components. 1, criminal investigation. 2, prosecution. And 3, sentencing. And I'm going to do something slightly counterintuitive. I'm going to save the investigatory discussion for the end, because it has with it some complexity that I'm going to need to burrow into a bit. So I'm going to start by talking about prosecution. Now, in starting off, the question I had for myself was, how often are we using the CFAA? And the place I went to for this information was something called the Executive Office of U.S. Attorneys, EOUSA. EOUSA keeps data, statistics, from each of the U.S. Attorney's offices on the prosecutions that have been brought in any given year, and they publish them annually in an annual statistical report. Now, I'm hoping there's going to be a lot of numbers coming on, and I think it was Vin Scully who said people use statistics like drunks use lampposts for support, not illumination. I'm hoping I'll be better than that today. So here you have an idea of what offenses we have generally brought in the federal system. In total, you're looking at 56,218 cases from last year that were filed. You see the various types of crimes we have prosecuted as a department: immigration crimes, violent crimes, firearm crimes, narcotic crimes. And those of you in the good seats in the front will see that yellow dot, and that dot represents the computer fraud cases. So last year, the department filed 194 cases across the country. And that was not entirely atypical. In the last 4 years, the pattern has kind of swung back and forth. It's trending upwards, but it's always been south of 200 and as low as 138. Now, this may still not answer a question that you have, which is, all right, so how often have you guys prosecuted computer security researchers? And for that, we didn't have any ready source of information. There's no box for computer security researcher on the forms that are provided, and it's not a searchable database. So what I did was, as I said, as CSIPs, we are responsible for supporting and training the field on this. We queried the field to ask them, how often have you in the last 5 years had either prosecuted a computer security researcher or had a pending matter? And I can tell you that we got a handful of responses that largely tracked what you have seen in the media. So there's no hidden cache of computer security researcher cases that we know. Now, I can concede that was not the most scientific method, but that was the best I had. So moving on from that. In the last year, the department has also attempted to implement policy to ensure that we have more consistent use of the CFAA. And in that, we have provided prosecutors with factors that must be considered when they're thinking about whether a criminal case actually satisfies a substantial federal interest. And the factors are not going to be really a surprise to you. They're fairly common sense type of things that you would think we would weigh. So, for example, the resulting harm. Did the activity drive a company out of business, or was there no real perceivable loss? The nature of the victim. Certainly, you may have one victim, but if you have secondary victims, for example, someone stole a database of customer information, you have other potential victims in that pool, and that may be a factor in how we think about whether we want to bring charges. The sensitivity of data. Are these medical records? Are these, is this PII? Is the sort of information that we would see flooding the financial markets, or I'm sorry, the kind of dark web markets, and commoditized and sold for profit? Harm to national security or public safety, or also potential impact on the integrity of markets, hack, pump, and dump schemes that we've seen. Things that have a larger impact because of the nature of the information involved, the sorts of facilities involved. Larger criminal activity. So if you look at our website and look at the press releases on the cases that we have been prosecuting, certainly over the last couple of years with great intensity, you'll see a number of transnational organized crime cases. And so we're seeing, for example, credit card fraud being used in support of other larger criminal enterprises, and that is also a factor we consider. And then there's deterrence. If, for example, we have either a new sort of crime or something that may not be understood to have the severity as a crime that should be understood, we may bring a case just to make sure that people understand that this is a serious matter. Now, I like to, in my presentations, have a so what slide just so you have some idea why I'm talking about the things I'm talking about. But here, the so what is the charging decisions that we are making under the CFAA are being guided by a policy that's relatively new, but is intended to give greater form and consistency to our use of the statute. In comparison to other federal crimes, we're not bringing CFAA prosecutions that often. We would like to bring them more, and actually we are getting better at bringing more of them. We're getting much greater cooperation internationally. We're able to reach out and touch people who we want to bring in for indictment more successfully than we have in the past. Again, looking at various people, Roman Seleznev, Vladimir Drinkman, we are able to reach into different regions of the country, in Vietnam, and not into Russia, but when one is traveling, and obtain defendants. But most importantly, I would submit that our prosecution of computer security researchers has been extremely rare. Now let's go to sentencing. As I mentioned, that there have been some concerns about what the sentencing practices are and how they work, and I thought it'd be helpful to explain how federal sentencing occurs. And it's actually, in my mind, kind of an interesting story. So decades ago, the way it all worked was Congress would pass a law. So, for example, we've got this crime, and the punishment is from 0 to 20 years. And a judge got to decide anywhere between 0 and 20 what that sentence would be in any particular case. So this turned out to be a recipe for great disparity. There was a study done in 1974 by judges in the Second Circuit, which is kind of in the New England area, where they pulled together 50 federal judges and they had them each sentence 20 notional defendants. And they took those results and they compared them. What they found was great disparity. You had a defendant, for example, who had a sentence under one judge of 3 years and another of 20 years. And so Congress actually took this up. Ted Kennedy proposed in 1974 the first kind of legislative solution to this, and it wasn't until 9 years later that the Sentencing Reform Act was signed into law by a great margin. It was passed in the House and the Senate, had bipartisan support, and was signed by President Reagan back then. What that law did was it took the same structure and it added math. Math that was intended to encourage consistency and kind of drive out disparity. So here's how that worked. So you still had Congress passing laws that gave a maximum sentence, 0 to 20, let's say. No, in some cases, the sentence isn't 0 to 20, it may be 5 to 20, because Congress can also impose a mandatory minimum. That is, they can say, for this crime, anyone who's convicted will serve at least 5 years. The one thing I'd flag is there is no mandatory minimum for any CFAA violation. That said, what the sentencing guidelines intended to do was it gave structure to this. There was a set of considerations, which I'll go through in a moment, that established a range in which judges were presumptively to sentence in. And generally that range was somewhere in the middle of this congressionally mandated longer stretch. In addition, a judge, though, could say, you know, this doesn't fit those facts, so I'm going to depart upward or downward. I'm going to do something outside the range. And the judge was required, though, to indicate why he or she was departing outside of the range. So greater transparency, again, ideas greater consistency as well. So what did this math look like? Well, it looks something like this now. The sentencing guidelines include, other than this list of factors that are factored into every sentence, a matrix. Once all the math is done and you get a number for each defendant, it is plugged into this matrix and it gives you the range for each defendant. It looks kind of Byzantine, I know, but the idea was greater consistency. Now, those factors I mentioned look something like this. Generally, you would take factors that were in the guidelines that establish the seriousness of the offense. So specific offense conduct. How was this crime committed specifically? Any adjustments that need to be made to that based on factors that were listed, like, was this a hate crime? Was this an abuse of authority by an official? Those would be factored in as well. Once you've got the specific offense characteristics, you start then looking at the criminal history. The offender, is this a recidivist? What's the criminal history of this particular individual? And then there's also aggravating or mitigating circumstances. So one of the ones that is used most frequently, let's say, is substantial assistance. If someone, let's say, testifies against or provides information about co-conspirators, that might be considered substantial assistance, and that defendant would get a bump down. And once you have all those numbers plugged into the matrix, you have a sentencing range, and the judge with a sentence. Now let's make this concrete. Let's do this for kind of a relatively run-of-the-mill hacking case. So you got bad guy, and let's just not make this bad guy a bad guy. Let's make this bad guy a ringleader. So bad guy actually organizes others. Bad guy has mad hacking skills. So uses his computer, goes out, gets some credentials, then breaks into a business. So a really bad guy doesn't just do it once, does it 3 times. Now, when the company finds out, they go out and they hire folks to mitigate the cost, and that cost is somewhere around $50,000. Now, let me say that I'm not just pulling that number out of the air. We also went to the U.S. Sentencing Commission to ask for data on the characteristics of crimes. Now, the U.S. Sentencing Commission is that body, and they collect the information from the judiciary. They are an independent body in the judicial branch, not the executive branch. And so we tried to get data about how the sentencing trends have gone. And unfortunately, it's 2012 because that's the most current information we were able to get for specifically computer-related offenses, but it's still kind of an indication. What this told us was loss, the median loss in a case of this sort, has been $20,000. So let's go with 50, which is actually much higher. And that goes into the calculation. Now, when we catch the bad guy, we charge him with 18 U.S.C. 1030A2, theft of information. How does that play out numerically? So, under the guidelines, a crime of this offense starts at a 6. A 6 on that matrix would give you probation. But then you have to add the additional factors. So here, you had $50,000 of loss, and there's a table that tells you how much to add based on different quantities of loss. Now, one thing I will flag for you here that may be important for the type of work you do is that the guidelines do in fact distinguish among different types of information. So, for example, specifically for credit card information, there's a specific valuation scheme that the guidelines provide. And some of the very large sentences you've seen are a product of the fact that credit cards are subject to this special valuation link. So we're dealing with credit card information. The likelihood of getting large sentences expands greatly. But in this case, we had passwords. There's none of that bump, but because this is an access device, there's an additional 2 points added. And because he had mad hacking skills, there's another 2 added. Now, we go to adjustments, and let's say in this case he decides to plead guilty, which is what around 94% of federal defendants do. And in doing so, he would likely get a 2-point reduction for acceptance of responsibility. And he did this on a timely basis so that we did not have to invest time and resources in preparing for trial. So he gets another 1 taken away. He was an organizer, gets 2 more points. Those are all the offense level information. Then we go to him. Let's say he had some misdemeanor convictions, nothing more than that. And then let's deal with the fact that he did this 3 times. The thing I would flag here is that I think there is a great misunderstanding about what that means. He does not get 3 times the punishment. In fact, the sentencing guidelines were intended to avoid that problem. In this offense, even if we charge those separately as multiple counts in the indictment, those would be grouped together, and the total harm, the total loss, all the factors related would be grouped into one and sentenced in one bunch. So it's not 3 times the offense, it's still the one singular offense. Let's say in this case he decides he does not want to inform on his co-conspirators, so he doesn't get the substantial assistance that otherwise would be due. So his final offense level is 15. You plug that in the matrix, and that's 18 to 24 months. And that would be the guideline range that a judge would consider. Now, these are advisory, but let's look at how often these advisory sentences are actually followed. In all federal offenses, in about 50% of the cases, judges sentence within the guidelines range. They depart downward close to 50% of the time. Upward, somewhere around 1 to 2%. And specifically for computer crime-related offenses, the departures are actually more often below the guideline range. So the average sentence we're looking at for a CFAA violation is around 29 months under the guidelines range, but the practice has been around 23 months. So I'd argue that what we've seen based on the data that we've been able to pull is that the average sentence for CFAA violations is around 23 months. And that routinely the sentences are actually below the minimum that would be laid out in the guidelines. I should lay out one thing that is a concession about the way the government does things and maybe how we've done something badly. In certain instances, people have said, oh, well, this person was obviously subject to overcharging because they're looking at 50 years. And when we say, well, that's not the way it actually would shake out, the response is, appropriately, but that's what your press release says. There's a 50-year maximum. Now, That's fair. That often is the case, and let me explain why that's the case. So first is we are often asked about the maximum when we do press releases by the media, asking how serious was this offense? What is the maximum sentence? The other thing, though, is, and more importantly, we cannot give a guidelines range because the factors that go into calculating that are not calculated until post-conviction. There is kind of an interview and gathering of information. So it's something that's done post-conviction. So at the outset of indictment, we don't have a guidelines range we can offer. So we have tended to take what literally is the most that could be given. Again, remember that whole range, 0 to 20, where 20 is the maximum that can be given and almost invariably is not, and provide that. This may be perhaps hindsight, not the wisest practice, but it is the way that we have done it, and that kind of explains some of the disparity between some of the figures you see and some of the sentences that are actually meted out. So I've now made the case, I think, that essentially we're not using the CFAA in a capricious way, that we are not coming after computer security researchers, that sentences are not really crazy, that this is not a case of prosecutors gone wild, which would actually be a horrible video, by the way. But we are actually, I would submit, relatively reasonable in the way that we're using these things. Now, does this mean that the concerns that we've heard about, the concerns about chilling, should be disregarded? The response to that is absolutely not. And here's why. We know that this is not simply a game of numbers. Right? So all it takes is one flogging in the public square, and there's a chilling effect. And so it has to be our goal to get this right. And part of the challenge is working with you folks to figure out how we can do that. Now, with all that in mind, I kept the investigatory phase as the last part of this talk because it is the hardest. And it is the hardest for this reason. When you think about what many computer security researchers do when they're probing for vulnerabilities on the internet, they will, go out, they'll scan the network, they'll figure out what the vulnerabilities is, release an exploit, and then maybe get some information back. I mean, it's certainly what the bad guys do. And then when a researcher does that, frankly, the problem is you look a lot like the bad guy, right? The ability to discern why you're not is not obvious to start off with. And the point here is when you're engaged in a certain type of computer security research, and specifically I mean that which involves probing another network that does not belong to you, the chances of there being questions about application of the CFAA have just gone up. And it's hard to avoid that. And frankly, on some level, it would be wrong if investigators weren't trying to figure out what you were doing because we don't know who you are. You could very well be that intruder who is trying to gather information that should not be gathered and is violating the law. So how do we get to a place where we are more readily able to discern what you are doing or to more readily dismiss, get through an investigative phase after knocking on your door and having a conversation? And that's something that we've had some interplay with folks in your community about. And let me offer a few thoughts on that. Let me break this down into certain types of activities. So let's start with vulnerability scanning. Obviously a very common practice. And I have faced the question of, look, is it lawful for me to conduct vulnerability scanning? And the problem is, I have to give the same answer I give to my agents or my investigators when they come to me and ask me a question like that. It depends. I can't just tell you off the cuff because technology is different. The type of packets you're crafting are different. The type of information you're getting back is different. So it's hard to offer that information in a vacuum. I can say this. If you're pinging a network, that is not illegal conduct. That's not actionable. I know of no prosecution that's ever been based on that. And I know of no one who's interested in prosecuting a mere ping. If you're port scanning, again, not a problem unless you're doing it at a level that is likely to, for example, result in a denial of service attack, somehow impair service. Outside of that, other vulnerability scanning, there could be questions about. What I would recommend, and this counts the same for mass scanning, is that you have on hand, let's say in the form of a web page or something that pre-exists your activity, an explanation of what you're doing and why you're doing it. So that if there is a knock on your door, you can say, oh, what I'm doing is that thing that I've got posted that explains why I'm doing this type of activity. And that is helpful. It also may help, oops. Hello? Did I just lose the mic? Is this live? Well, let's see. Can you hear me back there? Okay. I'm not sure what to do about the mic, but I'll continue. Anyway. Similarly, as we discussed earlier, there are, for us, factors that we take into account when we think about prosecution. And among these is the nature of the facility involved. We talked about the sort of harm that may be caused and national security concerns. So in the event that what you have is a scanning of critical infrastructure, I can tell you it's likely that we will look more closely at what you're doing because the possibility of there being adverse consequences is just greater. So there are precautions that you may want to take in advance of that, knowing that if you're engaged in that activity, we may have questions. So we're back. Thank you. As I mentioned earlier, that the type of information may matter, and here, if you're going to be scanning and you're going to be obtaining PII, first, I would recommend that you avoid that. But if you are not going to avoid that, I strongly recommend you minimize the information that you will be holding on to. Because, again, the ability to discern between someone who is collecting and harvesting PII for purposes of selling in the market and someone who is engaged in legitimate research is not easy. So authorization, it was explained to me that we had a discourse with several researchers about authorization, and they explained that this is maybe the least helpful of advice because a lot of this activity is happening outside the context of any sort of agreement or contract. Let me say, obviously, if it's happening in the context of a pen test or other type of contractual relationship, stay within the confines of that agreement. And if there's some ambiguity, ask questions before you engage in conduct that might fall outside of that. Otherwise, there may be issues under the CFAA. And threats. When you disclose, it is a good idea not to make that conditional on something of pecuniary value. What I mean there is saying, I will disclose this information unless you buy my security service, is a recipe for trouble. Now, let me just sum up by saying, we get it. You're engaged in something that is valuable. It helps us build a better, more secure network. We are not targeting computer security researchers. And in fact, we'd like to figure out how we can facilitate legitimate computer security activity. We're open to looking at the CFAA, finding ways of getting amendments that will allow us still to do what we need to do to safeguard networks while not unnecessarily infringing on your ability to do research. And that taking some common sense precautions will go a long way in protecting you. The last thing I'll say is that at CSIPs, we actually value transparency to a pretty good degree. And we have online about 1,000 pages of our legal opinions on prosecuting computer crime, on prosecuting intellectual property violations, including 50 pages on the DMCA, and on searching and seizing computers, the pen trap statute, the wiretap statute, when those may be applicable. And we encourage you to take that material, look at it, and absorb it. So with that, let me say thank you very much. I very much appreciate the opportunity to come and talk to you guys. happy to take any questions that you may have, and again, I'm happy also to hang back and answer any questions that are left. Thank you. Oh yeah, I'm sorry, and obviously those of you who don't have questions, feel free to leave, but. Yeah.
I was, I'm curious if you're willing to share your opinions on the prosecutorial behavior of the Aaron Swartz case and how that all went down.
Right. So not surprisingly, that was going to be number one with a bullet, right? I have to say this about that. I'm not on some level sure it's terribly helpful to get too far into that. I want to start by saying what I believe others have said, and which is very heartfelt. That was a tragedy. I think the world is far less interesting without Aaron Swartz in it, and it is, I think, unfortunate that we are here today without him. That said, the Attorney General of the United States, former Attorney General, Eric Holder, has said on this that he believes that the conduct of the prosecutors, the charges filed, were appropriate in that matter, and that there were a range of sentencing options that were available, including almost no time in a plea that was offered. I think we have to work to figure out how we can avoid such things in the future, but I'm not sure there's much more I can say about that. Other questions?
Yeah, I'm curious how you guys are reacting to the increasing threat of foreign nation-state attacks and also of victims of foreign nation-state attacks. So like, let's say someone got their PII stolen. How exactly would you react if like a victim was like frustrated with you, or like you guys aren't doing anything, or that type of thing?
Yeah, fair question. So obviously very much in the press are increasing attacks, it seems, from foreign adversaries. They may be nation states or they may be other parties in foreign nations. Let me kind of split this in a couple of different categories. So first, I'm from the Computer Crime and Intellectual Property section in the criminal division. There's a national security division that is focused on cyber threats to the national security. And they, for example, are the folks who brought the indictment last May of the 5 PLA members. The intent is to treat those like other criminal matters, and where we have the evidence, we will charge and we will be patient. One thing we're learning very much on the criminal side is that there was a notion that many people who we have indicted are beyond our reach. And what we've learned is that simply is not always the case. As I mentioned, if you kind of go through the list of prosecutions we've done, I mean, in the last year, we've had north of 24 successful extraditions. And so this notion that we can't reach people in other countries is not entirely true. National security cases bring additional challenges, but the government is looking at all various tools that it has to address those issues. So, for example, the president signed an executive order that's intended to, help go after foreign adversaries who engage in violations of cyber law. So, I think that's as much as I can say. We will work those matters. They may have some additional overhead compared to other more domestic matters, but they are taken seriously. Yes?
You mentioned that some of the more outlandish recent prosecutions have been brought by state governments rather than federal. So my question is there anything that can be done to help the state governments not bring those prosecutions? Or failing that, are there jurisdictional guidelines that would help security researchers not fall afoul of state governments? Okay, so good question. I do want to say one thing, which is I actually didn't say they were outlandish. I said they were not ours. That was my word.
Right. But with that in mind, one of the things we do is we do training for everyone. So we do train state investigators and prosecutors as well. We're not well staffed to train everyone, though. And as I think I showed, in each state and each, if you go to the number of local governments as well, you have tens of thousands of those. So, we can try to do what we can to make sure that people have a better appreciation for how criminal statutes might work in this area. But we probably are not ultimately going to be the answer to that. Other questions?
So you included a lot of statistics about how rare federal prosecutions are, but if someone is charged, they don't really care whether it's by state or federal attorney. So I was wondering if you had statistics about total prosecutions.
Right. So unfortunately, I don't. In fact, the problem is I don't even know where you would go to aggregate that information, because unlike the federal government, there is no hub for prosecutions across the country on a state or local level. Nor is there some body of information that I know of for example, civil actions taken under the 1030 statute, which are also a possibility. So the quick answer is unfortunately no. Other question?
May I?
Oh, yes.
Kind of along the previous lines, but I'd like to get your opinion really on education. So the congressional body, advisory body, on technology was done away with some time ago. Yet we have lawmakers who are creating computer laws without the benefit of advice. And to the earlier speaker's point, if you take the kid in Tampa, one of the quotes that I found disturbing was from the sheriff there going, "We charged him with a felony because God knows what else he did." That's guilt, where he's going to be proven innocent. So I'm just curious, for you, these come to you as cases, whether to prosecute or not, but I'm just curious just what your thoughts are in general on educating lawmakers and law enforcement.
So let me start by saying I am a very active proselytizer on the importance of understanding technology. What I believe is, unfortunately, right now, we live in a world in which, for the vast majority of certainly consumers, and probably policymakers as well, anything that happens beyond the keyboard is magic. It's simply magic. And there's no real appreciation for where information goes, where it resides, how it's kept, who has access to it. And it's very difficult to have a reasoned policy discussion in that environment. And so, for example, when we go out, we often talk about first the tech and then the law, so people understand how those things have to fit together. Your point about, should there be standing bodies that make that easier? I think that'd be a great idea. We do what we can in terms of our training, but it would make sense on the Hill to have such things. Hopefully, people are employing staffers who have such capabilities. I can say that we're fortunate. We actually had someone from our office asked to go up to the Hill to do some work, and he is a crackerjack prosecutor, one of the ones who was responsible for the Game Over Zeus matter on the law enforcement prosecutor side, and we believe he's adding value already. But it's a good question.
Hi. I'm particularly concerned about the application of the Computer Fraud and Abuse Act to activity that would be, let's say violations of terms of uses for websites and potentially for software, where you're faced with sort of a contractual limitation on how you may use a website or a service, and a lot of people don't read that. But ostensibly, if you collect information from a website in violation of the terms of use, it seems like the Computer Fraud and Abuse Act could be implicated. And given the fact that it's relatively easy to cross that line, it's a little bit different than sort of the hacker downloading some hacking software and then intentionally attacking and breaking into a network.
Right. So let me flag. It's a valid concern. The administration's proposal that we submitted in January, attempted to deal with this issue in the following way. So the administration has proposed the CFAA be amended to require that the value of the information that is accessed be at least $10,000. And the idea is to get trivial conduct out from under a criminal umbrella. So, terms of service, there's been concerns about, well, does that mean if I go to work, for example, and I look at baseball scores and my employer has told me not to, that I have now violated federal law? And our view is that obviously that should not be the case. And so we try to deal with it that way. There have been other proposals like the ICPA that expressly carves out terms of service. And we have some concerns about how that's done, because we still would like to be able to get to the insider who abuses access to a network. For example, we've had a system admin who's harvested information, including social security numbers, and sold that. And the way that we would go after that person in saying that was non-authorized access when you took that information was to say that your employment agreement said you could not do that. There are a couple of cases now, one in the Ninth Circuit, one in the Fourth, that suggested that we would not be able to do that, and we think that's problematic. So there are different proposals for this. There's an explicit terms of service carve-out that has been proposed by Senators Graham and Whitehouse that would address exactly what you're saying. We'd prefer to deal with it a different way, with this monetary threshold, but I think that's all to say that we're all trying to deal with this specific issue.
I have a question on, you briefly spoke about preventative measures that DOJ is going to be starting soon and trying to get more involved with. How is DOJ's approach going to be different than what industry is already doing?
Right. So everyone's in the cybersecurity game, right? The question is like, why aren't we just duplicating effort and doing this? One of the things that we're trying to do is to focus on what it is we do best, and that is we are the government's lawyers in many sense. And so our specific focus is finding legal impediments to good cybersecurity practices, and that's the way we're engaging with companies. We're trying to identify areas like that. For example, last year, we met with a variety of companies, ISPs, and we were told that they had concerns about whether the sharing of cyber threat information violated the Stored Communications Act. So we took that, we did some legal analysis, and we pushed out a public opinion that's available on our website explaining why, by and large, that is not a problem if you're dealing with aggregated information, which is usually what cyber threat information that's being shared is. So what we're trying to do is do things that are within our area of core competency, that is identify legal issues, and address those there. The CFAA, for example, is maybe an example of an area where there's a legal concern where we might be able to assist. Other question?
Hi, Leonard, you mentioned monetary thresholds. And so one thing that I think is ambiguous is what if there's monetary thresholds in the original statute that was written 20, 30 years ago, and because of inflation, those monetary thresholds now have a different significance, and now maybe the sentencing that is in the statute does not capture the intent based on that, the original intent of the law based on that inflation.
Right. So, unfortunately, if a statute has a monetary threshold baked into it, until Congress changes it, that is the law. That is one of the reasons that some have offered that that we need to amend statutes that have these thresholds in them. I think, for example, in the context of the CFAA, we are not opposed to altering so there's a $5,000 threshold in the statute, pumping that up to 10. The quick answer is we're stuck with whatever the statute says until Congress changes it. In this context, there are some proposals to change it, and we think, for example, going to a $10,000 threshold would be reasonable. Any other questions?
Yeah, I have one.
Oh, sorry.
Earlier you mentioned some sort of authorization. And there are some companies out there that actively ask for, bug reports, bug bounty programs from major players. But not every company is as forward-thinking. And don't take kindly to people looking for vulnerabilities in their product and reporting it to them. And that is a problem because it's in the best interest of everyone to identify these vulnerabilities and get them addressed before bad people do something with them. They discover them on their own and do something with them. So in that idea, you're not going to get some of these companies to authorize you to do this. They're not going to want you to do that. as an alternative, are lawmakers thinking about doing something along the lines of some sort of registration or licensing, like a private investigator gets? The same sort of thing. A cybersecurity researcher would be able to register that, hey, we're looking for these vulnerabilities, and we'll report them to the company. And some sort of standard period of time, 6 months, 3 months, whatever, that if they haven't addressed it, we then, what's done today is make it public, try to basically get them to fix their product in a rapid way, so to speak. But nonetheless, having it so that we're not vulnerable to being prosecuted by trying to do the right thing.
Right. So it's a very interesting idea. The idea of licensing, accreditation, some sort of certification.
InfraGard or something like that.
I understand that that is not necessarily a popular approach, though, within the computer security researcher community. It's a very complicated group that may not have a core. I can see the value to it because, for example, it would make some things easier for us if there were greater structure to the community, ways of talking about guidance and directives and the ability to get a kind of a coalesced view from the community. I don't know of any legislation, for example, that has that right now in it. Would be interested in thoughts from the community as to whether that was something that was favored. Again, I can see some definite value to it.
There are some sort of protection for those of us that are trying to do the right thing.
Right. No, thank you. Yes.
Yeah, so you say the value of the information that's obtained, it comes into account for how harsh a punishment is going to be. Does a prosecutor actually have to prove that someone has harvested or recorded the information, or is access enough?
Right. So, if you mean for the loss calculation.
Yeah. So, like,
Right.
if someone obtains access to a database that has lots of medical information, but they did not copy it, does the prosecution just only have to prove that they had access to the information? Is that enough to say that they have taken it?
So, under the loss calculation, let me start by saying that the question of valuation is always somewhat complicated because there is a question of, how do you actually evaluate the worth of different types of information? You can look at, for example, what things are going for in the underground markets and use that as a basis. Now, the fact that someone is in possession of, let's say, a huge cache of data, by and large, that is valued as a chunk, yes. Assuming that we can demonstrate all of the other elements of the offense. So in the instance of, for example, the hacker we sentenced here today, though, the loss value was driven as much by the cost of mitigation rather than the value of the passwords, for example, in that case. So, I mean, yes, certainly the quantity of information you have will be calculated and will be a part of the sentence. So I think that answers your question.
Well, so my question is more of, do you have to prove possession, or if you prove that they accessed a system that had the information on it?
I see, I'm sorry. Yeah, I mean, so yes, you have to prove yes. So the question is whether, for example, it was exfiltrated, right?
Yes.
Do we have to, yes, we would.
Cool, thank you.
Sure.
What would you recommend to a security researcher who accidentally accessed sensitive information, and possibly a proactive measure they could do to prevent legal recourse?
Right. So the first thing I would suggest is don't do it again. And to segregate that information to make it quite clear that you're not going to make any use of it. Then I would propose, I would propose you actually approach someone and deliver the information. There are different ways of doing this. I understand that there are third parties in the community who serve such functions. that may be of
mean
assistance. I'm sorry?
Do you mean lawyers here?
Uh,
Third parties?
Well, they're not merely lawyers. I think you actually have other entities that will serve sort of as go-betweens.
Like who?
Lawyers as well.
Okay.
You know, that may be another option. So you and I maybe want to have a talk offline because I could probably be more helpful then.
Thank you.
Sure.
How is loss calculation applied to items such as videos, photos, and those sort of things that may not have a direct value for sale in the sentencing? How is that all
I
applied?
see. So do you mean like not commercial
Correct.
movies
Like
or
so
pictures?
the celebrity photos for the iCloud hacking that
I
was
see.
recently happened.
So I have to admit, not an area I've looked in. And so my answer to you is I'm not sure. I'm sorry. I would rather give you that answer than give you bad information. So I'm actually not sure what the answer to that is. And I think, yes.
Are there minimum technical competency requirements for prosecutors?
So the question was, are there minimum kind of technical competency requirements for prosecution of the sort that? So no, there are no standards, for example, for hiring or things. Right now, what we do is we look for either lawyers who seem to have a tech background and who we know we could, easily onboard and use, or we just look for people who clearly are pretty bright and who we can train, and we are willing to invest in that. So the quick answer is no, there aren't any tech standards that are required. We do the best we can. Yes. Sure. Oh, sorry.
This is better?
Yes.
As you look at cases and when you proceed with them, do you also look at the organization if they have put in controls to protect the sensitive data, for example? Or do you leave that to their industry regulations such as PCI or HIPAA?
Right. So a couple things. One, it has been our practice to treat a victim as a victim. So first and foremost, when someone comes to us and tells us they've suffered an intrusion, we do not act as a regulator. We tend not to, look at their firewall and say, didn't patch, eh? But if, for example, there is information that, it depends on what statute we're dealing with, not under the CFAA, there are other statutes in which we actually do have to do that. So, for example, the Economic Espionage Act requires that someone actually treated their information as though it was secretive, prized information. And so if they didn't take steps like put NDAs in place or the appropriate protections, then it's not actionable under that statute. The CFAA doesn't have that requirement. The only place it could come up is if someone, for example, left a wide open system, then you can't argue it was unauthorized access because there's a big question as to who was allowed to access that network. But short of that, we would not really look at exactly how they have protected their network or their information.
So if they're using products, the organization is using products that potentially have a defect that allowed. So they're using products hopefully to provide some measure of technical control. Mm-hmm. And it turns out there is a problem. I guess that wouldn't fall under your area.
They're using a technical control.
A third-party solution, a third-party product internally.
Well, the only way I could see that coming up, again, is, we're going to have to prove the elements of the offense if we're going to bring a charge. So, my question would be, would this deficiency map to our ability to show that under the CFAA, if we were talking about that statute, that the access of whoever the defendant was in fact unauthorized? If it makes that question harder, if it was some technological glitch or something that made, for example, information readily accessible to the public, it would make a CFAA prosecution more difficult. And we would have to factor that into our ability or our willingness to bring a case, because it may not actually meet the requirements of the statute.
Okay, thank you.
Sure.
Question over here.
Yes.
Does the reporting organization, the victim organization, have any role or discretion in whether charges are brought? Do they have to press charges, or once they report it, is all that discretion up to the investigators and law enforcement to decide whether to move forward or not?
Right. So this is a good question. This comes up a lot. When I say that we tend to treat a company that comes to us with, as a victim, it means we try to avoid victimizing a company twice. So we work very closely to ensure that we are, not, for example, releasing information that might harm a company, that, we're working somewhat in lockstep because we need them by and large. Often we need to get access to logs, understand the network topology that requires their assistance. Now, if they suddenly say, we're done, we don't want to move forward, that really has to be assessed on a case-by-case basis. That makes a case very difficult for us, and we also do not relish, sort of compelling a victim to actually participate. At the same time, if, and this is, I think, an unusual circumstance, there was such a compelling federal interest in moving forward that the interests were beyond that of the company, would we have an interest in moving forward? Maybe. Let me give you an example. Let's say that what was taken, while it was in the company's possession, was in fact customer information. So there are others who have an interest in having their information protected. We might have to weigh that differently, right, than if it were just the company's information. So it kind of depends. Do you want to follow up?
Well, I guess the follow-up on that would then be, there's the protection of the secondary victims and those type of things. So if the company is doing the things like the credit monitoring or all those things to protect their customers that they've let down from that perspective, then you would argue then that there would be less of a case of having to disclose all of that information, because it's already been disclosed. There's no additional value public interest-wise.
Right, and I think that would, unfortunately, facts matter. So yes, sure. I think it depends on what exactly had happened, what sort of information was involved, and yes, in this circumstance, we would have to take that into account.
Okay, thank you.
Sure. Oh, sorry. Yes. Oh, you've got the mic.
Hi, I had a question concerning Fifth Amendment rights, as far as incriminating yourself.
Right.
You had mentioned a second ago about pressuring people who had been involved in activities into giving up information such as logs, encrypted information, that kind of thing. Can they still kind of hide behind Fifth Amendment on that, or?
I'm sorry, can they still?
Protect themselves via Fifth Amendment.
I see.
Yeah.
So in terms of self-incrimination, I think, one, I don't know of an instance in which we've actually compelled a company to assist us against their interests by providing logs or other assistance in a criminal matter. Right. Now, on the Fifth Amendment, I guess the question would be whether the logs actually demonstrate that they have some sort of criminal liability. By and large, that wouldn't be the case. They may be concerned about some civil liability that follows on, but the Fifth Amendment wouldn't protect them in that instance. Sure. Oh, okay, okay. Let's see, and there was a question here.
1 second. Hey, Leonard, I got to do something real quick.
Sure.
I've got to cut off the recording.
Okay.
Hey guys, we're going to cut the recording, so we'll continue questions off camera. Let's give Leonard one more round of applause. Thanks for coming out.
Thank you.